In April 2026, the High Court of Delhi issued a decision on an appeal originating from the Motor Accident Claims Tribunal. The appellant approached the bench with a sparse case file, failing to prove his primary claim, yet the court nearly doubled his initial compensation. This table tracks the specific shifts in the award. The original tribunal payout of 50,156 rupees was enhanced by the High Court to a final total of 90,156. Understanding how a failed argument resulted in a higher payout requires looking at the strict evidentiary divide the court maintains between pecuniary and non-pecuniary damages. The case began with a collision in March 2018. The appellant was riding a motorcycle on South Avenue Road when he was struck by a taxi driving on the wrong side of the road. While the rider suffered injuries classified as grievous, medical records show he was treated and discharged from the hospital on the same day. The claim was first heard at the Motor Accident Claims Tribunal, or MACT, in New Delhi. In 2021, the tribunal ruled in the rider's favor, awarding a baseline compensation of 50,156 rupees. This baseline established the starting point for the appeal. To increase this number, the appellant would need to provide categorized evidence for every additional rupee requested. The top half of the table lists pecuniary loss, damages with a calculable financial value, like treatment costs. The High Court left these unchanged from the original ruling. These medical costs were capped because the claimant's same-day discharge limited his quantifiable expenditures. To move past these caps, the appellant argued that the accident caused a significant loss of future prospects due to delayed education. At the time of the accident, he was pursuing a Master's of Computer Applications at the Indira Gandhi National Open University. He claimed a 3-month loss of concentration caused him to miss his exams and lose an entire academic year. While this loss suggests a clear financial impact, appellate courts require more than a cohesive narrative to grant pecuniary damages. In the lower tribunal, the appellant supported this claim using only his own sworn oral testimony as witness PW1/A. During cross-examination, the trial court record reveals a gap in the evidence. The appellant admitted, "It is correct that I have not filed any document to show that there was any academic loss." The court further noted that his testimony described a loss of concentration, but never explicitly stated that he missed a scheduled exam. The court is applying a formal rule of evidence. Uncorroborated oral testimony cannot satisfy the documentary burden of proof required to establish financial loss. Because no paper trail existed in the trial court record, the High Court upheld the tribunal's rejection, leaving the pecuniary damages frozen. The outcome changes in the bottom half of the table, non-pecuniary loss. Here, the court increased the award for every category to a flat 20,000 rupees. Non-pecuniary loss covers subjective damages, including mental shock, loss of amenities, and pain and suffering. This category requires a different standard of proof. While financial claims rely on receipts, quantifying pain and suffering requires a separate objective basis. The court used the medico-legal case report and discharge summary as that objective basis, allowing the judge to scale subjective pain against documented physical trauma. The summary detailed specific injuries, abrasions on the limbs, chest tenderness, and swelling over the left foot. The medical classification of these injuries as grievous provided the High Court with the objective justification to increase the non-pecuniary compensation. In the absence of financial receipts, the meticulous documentation of trauma in the medical record becomes a claimant's most effective tool on appeal. Seeking a larger payout, the appellant's counsel cited the post-amendment Section 164 of the Motor Vehicle Act. Counsel pointed to the 2.5 lakh rupee statutory cap for grievous injuries, requesting the court apply that maximum. The court declined to apply the 2.5 lakh maximum automatically. Instead, it used the spirit of the amendment to justify a customized lump sum enhancement rather than a flat payout. This confirms that statutory caps act as guidelines for judicial discretion in non-pecuniary matters, rather than guaranteed entitlements for every injury. Looking at the full table, the High Court's intervention resulted in an enhancement of 40,000 rupees. The court also applied a 6% annual interest rate from the date the petition was filed, increasing the final payout beyond the static numbers in the table. This successful 40,000 rupee increase was achieved despite the complete failure of the academic loss claim. The final award reflects the weight of the evidence provided, 0 enhancement for unproven testimony, and a calibrated increase for documented medical trauma. For practitioners, the primary lesson is that a bare trial court record cannot be fixed during the appeal. Pecuniary claims fail without corroborating documents, such as university letters or exam schedules, to survive cross-examination. For non-pecuniary claims, the priority is the medico-legal case documentation. Appellate courts will step in to recalculate awards if the initial tribunal undervalues an injury officially classified as grievous. In MACT litigation, the rule is consistent. Paper secures the pecuniary, while medical categorization dictates the non-pecuniary.